When we started the journey of Beyond Law CLC, my elder brother, Mr. Anil Malhotra, gave the flip to the ideas of webinars, and it was so encouraging that at that stage, he made us understand his favorite subjects. Therefore, after, I would say, quite a lot of time, we have requested him to share his knowledge in respect of interplay of Hindu adoption law and adoption regulations of Cara. Mr. Anil Malhotra, not only as a lawyer, but his passion to make these things easily understandable is not only known within India, but beyond that. I would say that he's synonymous with what we say in Beyond Law CLC. I will cut the introduction short because he needs no introduction as such. Over to you, sir, and thank you for accepting our invite.
Thank you, Vikas. First of all, I would like to let viewers on this platform know how incredibly proud and happy I am with Vikas, who has made so much Vikas that he makes his father, Major Chatrath, proud, who after a long stint in the army became a lawyer. And Vikas is following his footsteps in a very able and a very efficient way. Now, friends, just to introduce the topic to you, let us go back to all our mythological and historical perspectives. The goddess of wealth, Sita, as we all know her, was not born to a human mother. She was adopted by King Janak, and she was known later as an avatar of goddess Lakshmi. So, with this mythological and historical perspective, amongst the most popular religious personal law community, the Hindus, adoption of children, God lena, God dena, and even God bhrai were Hindu law propositions which did not require any court sanctity, which did not require any procedural formality, because who were in picture? The picture was the parents giving and the parents taking. So all our codified Hindu Adoption and Maintenance Act required was giving and taking, meaning the adoptive parents gave and the parents giving or the parents taking adopted them. So giving and taking essentially, which was supported by a ceremony of Dattahoman, which also is not considered to be essential, was all that was required to be done under the Hindu Adoption and Maintenance Act. Of course, there were conditions of eligibility that both parents giving and taking should consent to the adoption. The person concerned should be eligible to adopt. If you have a girl child, you cannot adopt a girl child. If you have a female, if you have a boy, if you cannot adopt a boy, and the mandatory age gap processes, etc. Now, additionally, Hamma said that if you register the adoption deed, it will be proof of the fact that the adoption has taken place. So, putting it very simply, if you did not register the adoption, it did not invalidate the adoption, it only proved that adoption took place. And it also meant that the adoption would date back to the date of the giving and taking ceremony of the adoption process. So the adoption date would be the date when the ceremony took place, when the giving and taking took place, not when the physical registration process took place, which was optional. So this is like performing a Hindu marriage. If you register a Hindu marriage, it doesn't date back to the date of the registration, it dates back to the date when the ceremony was performed. So in this backdrop, we as Hindus had this practice of adopting children within the family by parents giving and parents taking. Now, this concept also went further to parents who gave children who had so let us say 2 or 3 children, and who had another child, and they had a family, friend, relative, and therefore purely ethical, moral, and benevolent reasons wished to give their natural born progeny to a couple or to parents who did not have children. Now, this slowly became a very popular and a very easily acceptable social norm amongst the non-resident Indian community who did not want to who could not have a natural born child, so they took a child from the family. Now, this has been going on for a long time. Then slowly the malpractices in the area of adoption grew, and Lakshmikant Pandey's judgments of the Supreme Court in 1984 and 86 and 88 stressed on the fact that there is trafficking of children. Indian children are sold in foreign markets. Indian children are maltreated and abused. So Supreme Court time and again stressed that a regulatory mechanism needs to be created whereby checks and balances have to be brought in. So in 1984, in Lakshmikant Pandey 1, Supreme Court first laid down its guidelines requiring that in matters of adoption of orphan, abandoned, and surrendered children, a mechanism should come in place. So, under the Ministry of Women and Child Development, Central Adoption Resource Agency, it was an administrative body, it started regulating the processes. Then, as time grew by, India also signed the United Nations Convention on the Rights of the Child, in which the right of a child to a parent, a family, a home, a nationality grew. But India did not develop seriously, even though India signed the 2003 Convention on Protection of Children on Cooperation in Respect of Inter-Country Adoptions, 1993. Now, this is an international instrument as per which any country who signs this convention has to make an internal law within its country to follow the international principles of the convention and create a mechanism by which country to country children can be moved. So India signed this convention, but then again there was a go slow and nothing much happened. Then the law started to get evolved again from the Supreme Court. In 1980, in 2004, in Anokha's case, 2004 Supreme Court, Justice Ruma Pal upheld the adoption of a child whose parents, a taxi driver and a lady, had given their child in adoption to a foreign couple. The man had died. His wife gave the child in adoption with a pure benevolent purpose because the child would go abroad and have a better future. But of course, there were objections by Cara as to how this process was taking place. But the Supreme Court said nothing doing, the bonding has taken place, the child will have a better future, and in the better interest of the child was permitted to go abroad by orders of the Supreme Court. Now, meanwhile, the Juvenile Justice Act of 2000, year 2000, then 2012, and then ultimately 2015 came into play. And in the Act of 2015, because India had signed the Adoption Convention, the Juvenile Justice Act for the first time created a complete wholesome chapter on adoption of children, focusing more on adoption of orphan, abandoned, and surrendered children. Now, at the same time, the Juvenile Justice Act also created a secular mechanism for adopting children. which meant that once children were being adopted and parents were adopting, you may be belonging to Hindu, Christian, Muslim, Parsi, Jew religion, or whatever. You could adopt a child. But at the same time, your law under Hindu enactments to adopt remained intact. Now, in Shabnam Hashmi, 2014, Justice Gogoi elaborated the concept of adoption under the Jizya Act. And the Supreme Court said that the right to be adopted and the right to adopt is a fundamental right. And even Muslims can adopt under the Juvenile Justice Act. And Supreme Court also said that it is also the option of a Hindu to adopt under the Juvenile Justice Act as a secular law, or to adopt under Hindu Adoption and Maintenance Act as a Hindu. So the option was open and you could choose either. It is like saying I can marry under the Hindu Marriage Act by doing ceremonies, and I can marry under the Special Marriage Act without doing the ceremonies. It's my choice and I can adopt any path. Now then, at the same time, in the procedural backdrop came the decision of the Supreme Court in Stephen John Becker. Now, this was a very interesting matter of a 53-year-old American mother who had adopted a 10-year-old orphan. Now, under the Juvenile Justice Act and the adoption regulations prevalent at that time, there had to be an age limit up to which a child could be adopted. Now, this mother was ineligible according to the regulations under the Juvenile Justice Act. So, Cara declined, Family Court declined, High Court declined. Supreme Court overturned all the decisions. Supreme Court said the child is getting a better future. Bonding has taken place and allowed the child to go. So, in these backdrop of these decisions, starting from Anokha or going to Lakshmikant Pandey, 84, Anokha 2004, Shabnam Hashmi 2014, a law had evolved through the mechanism of the Supreme Court, laying down a positive path of rehabilitating children who were fit for being adopted so that they could get a better future. And at that point of time, we had over 12 million children willing to be adopted who were in a position to be given an adoption. But because there was no streamlined process, therefore, things did not fall into place. Now, slowly the concept grew. And the mechanism of inter-country adoptions came into play under the provisions of the Juvenile Justice Act 2015 and what came under them by way of subordinate legislations, the adoption regulations, first of 2015, then of 2021, and now of 2022. Now, the moot question which now comes is, insofar adoption of children under the Juvenile Justice Act is concerned, there is a streamlined procedure in respect of orphan, abandoned, and surrendered children. There are no parents giving, there are no parents taking one-to-one. So, Cara, now an authority, meaning it is now known as Central Adoption Resource Authority. It is a quasi-judicial authority exercising functions under the Adoption Convention in liaison with similar agencies in different countries. And how does this take place? So if you're willing to adopt a child from India, in whatever country you may be of Indian origin, you may be of foreign origin, you will register with the authority in your country or the agency in your country abroad. They will pass your request on. to the Indian Central Authority. Indian Central Authority also creates a registration process under their system called carryings, in which you can register, and your suitability to a child is matched. Consent from the country in which you are adopting is sought. You are assessed and evaluated by the agency in that country. And after that process is done, but you are matched with the child, you are physically able to meet the child, you are again assessed in India, and then ultimately the Child Welfare Committee or the committee under the Act and the rules now prepares a report which goes on to the district magistrate now and not the court, which makes a child welfare report, and that report is sent to Cara, and Cara ultimately issues a clearance for the child to go abroad. Now, as a practitioner and both as a person with deep academic interest, having authored 10 books, the process of adoption has undergone a sea change in terms of mechanics or dynamics are concerned. Now, what is actually happening, as I observe, is that Cara, Central Adoption Resource Authority, is slowly, by the adoption regulations or through the medium of the regulations, making changes which, in my view and my individual perception, subject to correction, is changing the provisions of the adoption law under the Hindu enactment and the JJ Act itself. So what is happening? The process of Hindu adoptions, which was a one-to-one process, has gone to a very slow mode, number one. Besides that, over and above, the procedural requirements and all the internal administrative mechanisms have become so cumbersome, difficult, tedious, problematic, that the number of adoptions, even of often abandoned and surrendered children, has dipped very considerably. There are write-ups, quite a few write-ups in the national newspapers and in journals, that the adoptions have gone to a very, very slow process. And it is very deleterious to the interests of children and to parents who wish to adopt children. Now, what exactly is happening as I see it? Now, first of all, the right to adopt under HAMA is a personal law right, unfettered by any law, independent of any other statutory provisions in any other enactment, and unamended by any other law, meaning thereby that the process of giving and taking makes the adoption conclusive, irreversible, and not subject to any change. Under Section 56, subsection 3 of the Juvenile Justice Act, in matters of inter-country adoption, even the Juvenile Justice Act says that all adoptions under HAMA shall be exempt from the provisions of the Juvenile Justice Act and the regulations therein, which means that there is a blanket carte blanche. There is a clear mandate that the Hindu adoptions are free from the procedural requirements of the JJ Act. This means that I do not have to register in the country from where I am coming to adopt. I do not have to go through the Cara's processes of testing. I do not have to go through the entire drill which Cara performs. Why? Because the parents giving and the parents taking are Cara. It is only in respect of orphan, abandoned, and surrendered children that this mechanism comes in. But then, The problem comes because if the child has to leave the country, a NOC from Cara is a mandatory requirement, without which the High Commission of the embassy concerned of the country on where the child is to go will not give you a visa, entry clearance, or permission to leave the country. Now, the internal mechanism of the Convention on Adoption says that if there are two systems of law in place in a country, which is a signatory to the convention, then both mechanisms will be recognized as due systems of law operating within that country. And the adoption would stand validated insofar that is concerned. Now, in this circumstance and situation, for any objection to be raised by Cara that the procedures under the adoption regulations have not been followed is meaningless. I say so because, first of all, there is a carte blanche under section 56(3), which says all procedures are exempt. Second is the requirement of an NOC under Cara can be simply given by Cara overseeing the process, checking the mechanism by which the adoption is taking place, doing an internal extra check, submitting a report to Cara, and then Cara giving a no objection certificate as an alternative for the requirement of the visa purposes, and writing to the embassy explaining the circumstances that this is a personal law adoption under the dual system of law within India, and that can happen. But in reality, what is happening? In reality, what is happening is that pursuant to the judgment of our Honorable High Court, Punjab and High Court in Jasmine Kaur, in which I was an amicus, a judgment of the Delhi High Court in RK, and another judgment of the Kerala High Court, where the court started saying that these Hindu adoptions are exempt from the process of the regulations and procedures of Cara. Cara amended its adoption regulations and brought about a brand new procedure whereby they said that all adoptions under Hama will also have to undergo the process of a prior clearance from the country to where the children were to be taken, and then the process has to follow. Now, how on earth is a country in which the child doesn't live, in which the child has not been adopted, be able to certify and verify the Hindu adoption? Everything has taken place in India. Parents giving and parents taking are in India. Child is in India. So, in my view, amending the regulations by delegated legislation to override the provisions of the JJ Act, where 56(3) says Hindu adoptions are exempt, and diluting and nullifying Hama, makes these adoption regulations ultra vires and unconstitutional, being against the legislation made by Parliament, because delegated legislation cannot supersede mandatory statutory regulation. Now, the second thing which Cara has done is that they have changed the word court to district magistrate, which means any documentation which was originally to be verified by a court, which meant a judicial court, be it a subordinate court, meaning it could be a civil judge, or it could be a family court, they have substituted it to the district magistrate. Does the executive authority have the wisdom, the judicial eye, and the mechanism to assess, evaluate, and find out the best interest of the child? Can a district magistrate with a checklist on the basis of a report given by the Child Welfare Committee certify the best interest of the child? Is the adoption process akin to issuing a license, quota, or a permit by a district magistrate? The answer is no. So in this process, trying to expedite the entire exercise by passing it on to a district magistrate who is occupied with 200 other things, falls foul of the entire process of the best interest of the child. There can be a fast track mechanism to take on adoptions, but giving it to a district magistrate through a child welfare committee and Cara sitting in control over the decision of the district magistrate is turning the cart upside down. So court has become district magistrate and Cara has become court. And the other difficulty is, as I see it, Cara is now a quasi-judicial authority exercising functions, statutory mandatory functions under the JJ Act. Cara should therefore, in my most humble view, be headed by a retired Honorable Chief Justice or a retired judge of the Honorable Supreme Court of India. Because what is required is application of principles of law, not administrative rules, trying to envelop as much as possible because Cara wants control. Cara is headed by a steering committee in which the Secretary of the Ministry of Women and Child Development is the chairperson, and it is full of a bevy of officers and administrative staff from Cara who probably do not have the perception, the thought process, the understanding, the way to interpret and to implement the provisions of the convention. It's a simple, plain reading of the convention. There are two systems of law in a country. The convention says both will be recognized. They have to, the judgment of the Supreme Court, the judgment of the Delhi High Court by Justice Pratibha Singh and Justice Nirmaljeet Kaur in the Punjab and Haryana High Court spelled out that you should create a mechanism which is friendly, which is expeditious, which is a class apart from the normal process for orphan abandoned children, so that children keep moving. Now, things have gone so far that in a judgment reported by the Kerala High Court in Sivarama in 2020, the overzealous Child Welfare Committee went to a home and picked up children adopted under Hama by parents giving and taking, saying the CWC had not given any clearance. Now, where does the CWC come in a family-to-family adoption? Nowhere. Now, this has come a little further. As recent as 11th of August 2025, in the case of Dasari, where Honorable Bench of the Supreme Court, headed by Nagaratna, has said that the best interest of the child means regularization and rehabilitation of the child. So best interest regularization is the principle. Cara is to facilitate adoptions, not frustrate them. So Supreme Court has used Article 142 to restore the children back to the parents, adopted parents, even though there were some procedural irregularities, meaning thereby that there was no clear transparency on how the children had moved. But the fact of the matter was that the children had been rehabilitated with parents who had taken them in adoption. And there was a bonding and they were being well looked after. There were no issues of trafficking. There was no issue of any maltreatment, etc. So this has gone that far that this is now being viewed in a separate perspective. There is another pending matter, I would not like to quote or name or rely on it, in which a similar thing has taken place in respect of an inter-country adoption, whereby the court said you have to give a clearance. It's a family-to-family adoption. You have no role in it except to certify it. So meaning thereby, Cara can ask for a report via the district magistrate for whatever the procedure requires and whatever he is worth. The district magistrate in turn will get a child welfare committee or some other committee to evaluate the best interest, talk to people, have the assessment done, meaning is the child happy, is the parent fit enough to adopt, what are living conditions abroad, and furnish a report. That's the end of the matter. Now, what Cara also needs to understand is that their giving an NOC will not permit a child to leave India. The parent concerned has still to cross the hurdle of getting the approval or getting the acceptance of the child in the country to where the child is being moved insofar as the visa process is concerned. No foreign mission, no foreign embassy is going to issue you a visa for the asking. They will look at the Cara University and they may require other requirements to be fulfilled insofar the country, USA, England, America, Canada, Australia are concerned. For example, the American regulations say that the adoptive parent who has adopted the child should be living in India for at least 2 years with the child before the child can move out. And then they say we have no objection provided Cara has given an NOC. Child moves. Likewise in US, in UK, they say if you have an NOC from Cara, you can seek an order, adoption order from the UK authorities, or you can register the adoption and take an approval from the Home Secretary before you can be issued a visa. So there are processes, checks, and safeguards. Still further, Cara can also monitor these adoptions through the agencies, meaning the High Commission or the embassy of the country concerned overseas, as is stipulated in the adoption regulation. But the Cara cannot block them and sit over them. So it is this proposition which was created to streamline the process of adoption in the wisdom of the Supreme Court in 1984. But what is coming out in 2025 in the Savi's case is that the entire process has gone into a go-slow mode, not only for relative adoptions, inter-country family adoptions, orphan abandoned surrendered children processes, as also of all domestic adoptions. Figures show that the number of children going in adoption, even domestically or internationally, is dipping. There, the streamlining, the cohesion, the working in tandem has gone for a 6. The entire idea of India signing the United Nations Convention on the Rights of the Child was that the best interest of the child should be subserved. It was made a part of the Juvenile Justice Act. After India signed the Adoption Convention in 1993, adoption became a fundamental right of the adoptive parents and of children to be taken in adoption. But how far has the implementation taken place? General principles for the welfare of the child laid down in the JJ Act, principles laid down in the UNCRC of a right to a home for a child, a right to be looked after by parents, a right to a nationality, are slipping down. If we look at Article 21, there is a right to life and personal liberty. Now, right to life has very vast connotations. Right to life under Article 21 means right to life of an adopted child to be adopted. Right to life of childless parents is right to life for themselves of a child or for adopting a child. We have Article 8 of the European Code of Human Rights, whereby the code in Strasbourg says right to life is a very progressive and a very far-reaching right. And right to life is known as right to family life in European jurisdiction. I think our Supreme Court is already interpreting right to family life under Article 21. But the point is, do we need Article 142 to bring into place right to family life and adoptions? Despite the fact that HAMA is very clear, procedures and guidelines of the Adoption Convention of 93 are clear. UNCRC is clear. Why is there a fault mechanism? Why is there not a system prevailing by which the process is to move streamly? Instead of going downstream, we are going upstream. Now, in this perspective, the adoption regulations, which are contravening the provisions of HAMA and which are contravening the provisions of Section 56(3), whereby Hindu adoption is exempt, need to be seriously looked at. Besides, a statutory mechanism overlooked by a retired Honorable Chief Justice or a retired Honorable Supreme Court Judge needs to sit in the position of chairperson of Cara and regulate the process of at-home, in-country adoptions. Why can't we move faster? Why can't the regulation be relaxed? Why can't we follow the provisions of the Juvenile Justice Act, incorporating the Adoption Convention, which was meant to facilitate adoptions? The whole idea is not to create a bureaucratic administrative mechanism to frustrate adoptions. So it is this overlooking of my entire viewpoint of, let us say, from 1986 onwards till 2025, that I see that we went up, we stayed there, and we're going down now. So with this thought process and with this perspective in mind, I now put it to Vikas to ask people if anybody has any questions or anybody has any viewpoints to share, and we can look at those issues from there.
There's a general statement in respect of Dr. Piyush Saxena that it's a big resource. I would just, like we had said in the earlier, if you could also summarize bird eye view in Hindi for the audience who would love to understand all this in a bird eye view in a 10 minutes session.
Yes, why not? बच्चा गोद लेना या बच्चा गोद देना हिंदू धर्म में हिंदू कानून के हिसाब से एक मानी हुई चीज है, प्रथा है, जो कि भगवान सीता जी के टाइम से चली आ रही है। क्योंकि सीता जी जो भगवान लक्ष्मी के अवतार थे, उनको राजा जनक ने गोद लिया था। तो ये हमारे हिंदू धर्म में एक प्रथा है कि हम गोद लेना, गोद देना अपने हिंदू धर्म की संस्था मांगते हैं। क्योंकि जिन माँ बाप का बच्चा नहीं होता, वो चाहते हैं जी हमें भी औलाद का सुख मिले और हम बच्चा गोद ली सके। तो इस व्यवस्था के लिए हिंदू धर्म में कानून बना। मगर इसके अलावा जिन बच्चों के माँ बाप नहीं होते, जो लावारिस होते हैं, या जिनके माँ बाप गुजर गए होते हैं, या जिनका देख रेख करने वाला कोई नहीं होता, ऐसे बच्चों के लिए भी गोद लेने की संस्था या प्रथा बनी, जो कानून में उतार दी गई। और उस कानून को लागू करने के लिए एक सिस्टम बना, जिस सिस्टम के आधार पर ये सारा काम चलता रहा। पर ये व्यवस्था होने के बावजूद भी अब जो कानून बना है कारा के अंडर, रेगुलेशंस के तहत, वो कानून में इतनी मुश्किलें और इतनी अड़चनें पैदा हो गई हैं कि उनको पूरा करने में इतना समय लगता है कि जिन्होंने बच्चा गोद लेना है या जो बच्चा गोद लेना लिया जा सकता है, उसमें बहुत अंतर आ गया है। इसके कारण से ये सारा बच्चों का गोद देने का सिस्टम जो है वो अब बहुत धीरे हो गया है। और 40 साल में जो तब्दीली सुप्रीम कोर्ट ने ला के दी थी, वो तब्दीली अब इतनी कामयाब नहीं रही है। और हर वक्त कोर्ट जाना, कोर्ट के तहत रिट करके या केस डाल के कोर्ट के ऑर्डर लेने, हर आदमी या औरत के बस का नहीं है। खर्चा है, टाइम लगता है, समझना भी पड़ता है, और उसके बाद अपील हो जाती है। तो क्या ये बच्चों को गोद लेने का जो कानून है, बच्चों की मदद के लिए बना था या बच्चों के इंटरेस्ट के खिलाफ बना था? सो उसके बाद अब ये सिचुएशन आ गई है कि अब सुप्रीम कोर्ट अपनी बड़ी अलग से हटके जो पावर है उसको इस्तेमाल करती है बच्चों को वापस लाने में। तो मेरा मानना ये है कि ये अब इस चीज पे किस्सा इस किस्म के जो किस्से हैं उन पे नजर डालना बहुत जरूरी हो गया है। और सरकार को चाहिए कि जो सिंपल करने के तरीके बने थे उनको वापस लाया जाए, और ये जो कानूनी अड़चनें पैदा करी गई हैं और ये जो प्रोसीजर की मुश्किलात आ गई हैं, उनको खत्म कर देना चाहिए।